Good morning, everyone. I would like to thank, first of all, the CMC for having organized this event. It's a pleasure. I belong to the Spanish bar, and I'm extremely happy to be here, not only because of what this day means, but also because I think we are in the first league of competition authorities, and I say it honestly. And this is the reason why they have organized this wonderful day with an extremely interesting discussions we're going to have. This first panel, we're going to discuss something that we have heard a lot in the past, is an endless discussion and debate about ex-ante regulation. Do we need more ex-ante regulation, or is it better to have ex-post application of competition tools? What are the gaps of Article 101 and 102? I think that the Commission and scholars and practitioners, we have devoted thousands of paper against the Amazons, just writing about these gaps. Well, maybe we have found these gaps and now we have new regulation. What is better? Then we have many other questions about how competition and regulation interact, how authorities are going to interact, who is going to apply it. Are we going to have double jeopardy situations, 2 sanctions for similar behavior? How large companies are going to be able to comply with competition laws and this ex-ante regulation? Many questions arise. In order to debate on these matters, and I will not extend too long on these, we have a wonderful panel here. I think that we cannot find more suitable people to discuss about it. I will start introducing a little bio, because you have a very, very long bio, very long CV that has been distributed to all of you, of these 4 panelists. I start with Inge Bennett. She is a public servant since 2003. She was also, and let me use this quote, in the other side of the force. Before that time, you were a private practitioner of competition and EU law before. She has been working since 2010, I guess, or maybe a little bit later, in the, she's director of strategy and policy in DG Comp. If we look at what she does, she's really a multitasking civil servant. You have been responsible for implementing almost everything in terms of policy, vertical guidelines, the review of the horizontal guidelines, also the simplification of merger control, foreign subsidies, Digital Markets Act, etc., etc. So definitely, if I want to change something in my life, I need one Inge. And it's clear, at least for the results. Previously, she also worked at the European Commission in the Energy Director General, and also she was in the Cabinet of Employment, Social Affairs, Labour, Mobility, etc. Then in my right side, I have Rita Wesenbeck, who I know from her past life in DigiComp and dealing with telecoms and other sectors, but now since 2020, I think, more or less.
A year.
Oh, a year. Yeah, that's true.
No, depends on what you want to say.
I was going to say you're present on your current post is at DG Connect, and well, you are responsible for the implementation and surveillance of these new policies on online intermediary services. Probably a lot of headaches and a lot of work, DMA, DSA, etc. As I said also, well, you were also a private practitioner, you were on the other side of the force, so I think it's good to have these 2 sides, because companies always complain about a lot of regulation, but we have people who has been advising companies in regulation and competition law.
Like energy.
Then I think that maybe a wonderful exponent of this is Martijn Snoep. Well, he is the chairman of the Netherlands Competition Authority, which I always say competition authority, but is also a consumers and markets authority. So I think you have on the same hat consumers, DMA, DSA, and competition, so full package. Well, his CV is quite short, but I know him also from his previous side as a lawyer, working at the Brow, and for many years you were also managing partner there. Something he does not say, but I allow myself to say, that you were also vice director of an orchestra, and it's something that reveals that he can manage and organize whatever he's got in front of him. Good skills, definitely. And I think he's one of the most well-known people in Europe for his efforts to push for sustainability developments in the area of competition law. And I really admire all his work, and at least is food for thought. And of course, Massimo Mota, the only non-lawyer or non-background lawyer, but he knows about a lot of law. Massimo Mota, he's an economist, he's a research professor at the University Pompeu Fabra, as well at the Barcelona School of Economics. He served for many years as chief competition economist of the European Commission. He developed the idea that we are now suffering about mergers that they need, the Commission needs to be a little bit harder in review of mergers. I'm not criticizing this, I'm simply making that point. He has been advising for many years to competition authorities, agencies, well, he has written a lot about competition law. I think you have written the basic textbook on competition law in exclusionary practices as well. Definitely you will have to write something about abuses of dominant position in the future, I hope. So we have a panel with economists, enforcers, ex-lawyers, with these two sides in mind, and let's try to bring some light to this interaction between competition and regulation. And I will start with a couple of questions. Of course, anyone can jump. This has not been practiced. I will try to get the clock very tight, but please discuss and intervene whenever you feel it works. At the end, we will have 15 minutes for discussion of the floor. My first question, Massimo, this is for you, and it's just to put us in a context. Traditionally, and I'm very basic here, when I look at regulation ex ante, I always thought about kind of ex-monopolist markets, which we had the incumbents, we needed to liberalize, and that's why we needed ex ante regulation to give fair opportunities to new entrants. But the incumbent, he didn't do anything special. He was just a monopolist, a previous state-owned company. But now we see that these market failures affect other sectors. We look at the EMA, DSA, etc. What has changed? What do you think that has changed that needs now regulation ex ante in completely different scenarios from an economic perspective?
Thanks, Patricia. So I don't think there is something which has changed dramatically from one moment to the other. It's just that these market failures that you are mentioning are particularly concentrated in the digital sector, so it does basically become evident to everybody that competition law approach was not enough. So just to try and set the stage more generally, I think we are used to think of basically the economy as divided into big sectors. One where, as you were saying, because of legal monopolies or because there is a national monopoly, you are aware that market forces are not working, and therefore you have sector regulation. And then you have all these other sectors in which a priori you would think that market forces are working well. And these are the sectors in which it is competition law which should intervene, but occasionally and in a targeted way. And perhaps it's also the fault of we economists that we say, well, what happens is that if there are possibilities to enter the market, that is, if there are no legal barriers to entry, then what is going to happen is that, attracted by profits and by high prices, there will be some firms which are going to enter into the market. They will lower market power, and in this way, consumers will have better outcomes. Unfortunately, although in some sectors, indeed, it might happen in this way, what happens is that there are other sectors which are characterized by a number of market features which are such that you cannot expect that the market is necessarily working very well. What I'm referring to, for instance, is the presence of economies of scale, economies of scope, network effects, which can be direct or indirect. You can talk about two-sided markets. You can have switching costs, lock-in effects. You can have behavioral biases. All of these effects and market features that we are now familiar with all these reports that have been written about the digital sectors. But you have to keep in mind that all these features which protect the incumbents are features that you can find also in other markets. What has happened is that basically in the digital markets, all of these market features have been concentrated, and this has meant that basically monopolistic platforms had basically unassailable market positions. So market features is something for which might explain why competition law might not fix the problem. But there is also something else, that is that in some other occasions there might be conduct that competition enforcement is not able to fix because it is too slow, because it is too complex. And therefore, what has happened is that we have seen situations, for instance, in which the use of Article 102 has not been sufficient to fix the problems. Just think of cases such as Google Shopping. Google Shopping, the investigation was formally opened in 2010. When I arrived at the Commission in 2013, the investigation was very much underway. There were commitments which were discussed. When I left the Commission in 2016, the decision had not been taken yet. The decision was taken in 2017. Then there has been the judgment of the General Court, and now we are waiting for the final judgment of the Court of Justice. We are talking about a situation and this is also what is clear about the digital markets. We are talking about the situations in which we have a market which changes dramatically from one day to the other almost. So having a decision which might take even 10 years is something which basically means that you are intervening when things have already developed in a way that you cannot control. To this, you might also add that, as you were saying before, that the merger enforcement, I think that it has been too weak, and then this has created this situation in the digital sectors that we are witnessing now, and which has left us with just one possibility, which is to have a more regulatory-like approach. However, and that's the last thing that I'm going to say for now, I think that there are other sectors in which you might have similar problems. And I would not advocate for having a regulatory-like approach everywhere in all these sectors, but I think it's important that we think of introducing an additional instrument that you can think of as something which is in between competition and regulation, which is market investigations. From this point of view, when the European Commission started to talk about a new competition tool, I had high hopes that it would move into that direction, also beyond digital. To me, this has been so far a missed opportunity, not by everybody, because, for instance, Germany has introduced a market investigation system. So I think that this is the direction in which we should also try to move. Thanks.
Thank you, Massimo. I think that for the new competition tool, we might need another conference the whole day. I would probably be seated just in front of you, debating heavily that. Having said that, maybe we can address it more in detail at the end, because if we focus on the new competition tool and the German initiative, etc., maybe the traditional element between competition and regulation, because this is in a midway, we can skip there in the debate. Now, I will address to all the panelists something which is quite basic, but I think that something has changed dramatically with the DMA as compared to the DMA, the Digital Market Act, and a DSA as compared to traditional regulation. And I would like to know your views. I know it's a very, let's say, broad question. What was the traditional relationship between competition and regulation, and what has changed? To what extent the DMA has changed this relationship? And I can put you some examples. I mean, is a DMA any kind of regulatory tool that we have not seen in the past, because it also mixes some concepts with that comes from competition law. We're not talking about dominance. We're talking about gatekeepers, but some people may mix it. Also, in my view, I think that the DMA introduces radical changes for market players, large digital companies, and the way they have to behave. I want also to know your views, also from a policy perspective, that was meant to be that way. What do you think that these changes will bring us, and where they will bring us? So it's a very broad question: interaction, competition, regulation. What has changed, and what are the main novelties that the DMA have introduced? Any of you, of course, you can start with that.
Happy to start. Good morning, and thank you for having us here. The interplay between regulation and competition, the first point that comes to my mind also when going back a bit in time to the 90s and the origin of these liberalization packages of network industries, is that what I see as a common theme is that often competition law enforcement informs you well about how markets function and what bottlenecks are in markets. And therefore often that's how it worked also at the European level. Competition law enforcement gives a basis and helps to design pro-market, pro-competition regulation. I think that's something that we've seen in telecoms, in energy, and that we have definitely also seen with the Digital Markets Act. And again, if I look across these three sectors where I've been involved in most deeply, you see that one problem that often exist is the combination and actually natural conflicts of interest almost in dual roles that operators with a lot of market power play, whether that's the owner of energy networks who also provide services, or in telecoms, or in the Digital Markets Act now, companies who hold gatekeeper positions and leverage that into other positions. And therefore I think also in seeing how the regulation was shaped across the sectors and comparing that to Digital Markets Act, you see common themes in terms of access regulation, interoperability, facilitating indeed customers to switch from one operator to the other, to port, whether that's then their data or their mobile phone number. So I think there is a lot of consistency in the basic approach to regulating market based on competition law knowledge and experience. I think what's also a common element is the complementarity of competition law and sectoral regulation. Again, going back to telecoms, to energy, competition law has been enforced next to regulation and hand in hand with regulation, and that's what we expect also for the digital sector. Where I see some differences, and again, I think that comes back to the origin of markets and the fact that in telecoms and energy, we were talking about liberalization legislation, which opened up national markets to competition. That is something which is different in the digital sector. And you see that in the enforcement architecture, whereas for energy, for telecoms, the center of gravitas and regulation was in the member states, with then the Commission playing a coordinating role when it comes to the Digital Markets Act. The central enforcement powers lay with the Commission, whilst relying on national authorities to do that work as well. What we expect to see in terms of changes is, of course, changes on the ground. And we hope that by moving to ex-ante regulation, where the specificities of the obligations are written in more detail into the law itself, that will facilitate that type of compliance, and that there is less need for discussion about what compliance means exactly. That's not to say that there will not be discussion at all about this. I'm sure there will be plenty of discussion, but at least the provisions, the do's and don'ts in the DMA are more concrete and more precise than the general principles that are laid down in Article 101. And yes, indeed, the changes that we hope to see go to the heart of business cases of some of the big tech, precisely because they play, for example, to these dual role issues that I mentioned before, because they play to the business case of harvesting data and using data as the new oil for some of these gatekeepers. So that in terms of just some introductory comments to your questions.
Thank you very much, Inge. Martijn.
Yeah, thank you very much, Patricia, and thank you very much also to Kani and the team for inviting me here. I can say that because we have an overwhelming majority of lawyers here on the panel, is that lawyers like to put things in boxes and then draw inevitable conclusions from it. This is not competition law, this is regulation, and so it is absolutely logic that it can't do this or can do that. And I think we have to be very careful. So, and wonder whether the distinction that is sometimes made between competition and regulation is actually that different. Ultimately, the goal of competition law and of regulation, the type of regulation we're talking about today, is to protect and stimulate competition. And that is the goal. And there are slightly different means, but that goal is extremely important. Because competition, as we feel around this room, is important because it keeps in check corporate power, like free elections and democracy keep in check government power. And therefore it is essential that we as a competition community continue to protect competition. And this distinction between competition and regulation is somewhat artificial. If you take, for example, the refusal to give access to an essential facility, which is an abuse of a dominant position under 102 and then many national laws. And there is an ex post effect that competition authorities can fine companies who refuse access to that facility. But there is also an ex ante effect because it's a deterrent effect, and as a result of the law, people ex ante, companies ex ante, decide to give and to grant access to an essential facility. So a competition law has both an ex ante and an ex post effect. And the same goes for regulation. If we take the type of regulation that promotes and stimulates and ensures access to an essential facility, whether it's in the financial industry, in the energy, or in telecoms, the goal is the same and the effects are the same. There is an ex post effect in the sense that companies who refuse access to that essential facility infringe specific regulatory rules, specific regulations. And there can be an ex ante effect because of the deterrent effect of these rules. So it's exactly the same whether you now apply 102 or apply specific regulations. The goal is the same, and that is to protect and stimulate competition. That doesn't mean that the DMA and the regulatory package that comes around with it is not fundamentally changing the dynamics. And there, I think there are two fundamental changes in that the DMA bring about. First is a purely centralized enforcement system. That's contrary to competition law, where there are shared responsibilities between Brussels and the member states, but we have a purely centralized enforcement system. And second, there is a continuous focus on a specific set of companies, the gatekeepers, that are determined in advance. And that makes those two things make the DMA a very different animal. Same goes for the DSA to a certain extent. Two minor points. The centralized enforcement change makes it absolutely crucial that not only that the national competition authorities and the national authorities entrusted with enforcing, those small parts of the DMA in the national member states work together as a team. Coordination between the national authorities and Brussels is even more important because basically we are all focusing on the same companies and the same type of behavior, and it would be a complete waste of resources and lead to great legal uncertainty if there is an uncoordinated approach. Second point, what is important is that the dynamics change in the sense that now we have a specific set of gatekeepers that need to comply with new rules and that require a significant, for those companies, requires a significant mindset in how they operate. They become regulated industries. And being a regulated industry and being a regulated company requires a different ballgame. We know that. We are also the energy regulator and the telecoms regulator. We engage in regulatory relationships with the regulated companies. And the regulated companies need to enter into a regulatory dialogue with the enforcer. And that is type of work that many of the enforcement agencies are not used to do, and that we need to develop over time. So we have a big change on both the side of the regulated companies that need to adapt to a regulated environment, and the competition authorities that are not used to enter into a regulatory dialogue. And those two changes, I think, are much more important than change in the dynamic of how we enforce all these competition and regulation laws with the goal to protect and stimulate competition rather than the dogmatic distinction between competition and regulation.
Yes, what still to say after this? I think there was an excellent market analysis of Massimo, and I fully subscribe to all the elements signaled out already by Inge and Martijn. So it becomes a bit of discussion about the gender of angels, I think. But, well, maybe points to add is indeed this regulatory dialogue. I think an important element is indeed that other than having a battle every 5 years, we will have a long-standing relationship with the regulated entities, with the gatekeepers and the very large online platforms under the DSA. And so that means we will see them regularly. I mean, in practice, that has all kinds of practical aspects. So there will be a compliance function. So there is a cell within, or a team or an entity within the gatekeepers who are our regular interlocutors, which is completely different from an antagonistic dynamic in competition law. It also means, for instance, that for a certain part, the gatekeepers are in the driving seat. So we are now in compliance mode. And for us, this is clearly not a paper exercise. So it will end with a compliance report that the gatekeepers will hand in. But we expect of them that they will work towards solutions and they will test those solutions. So part of the work is really proactively in their hands. That doesn't say that everything will be solved in March, but it's a dialogue that they also need to have with their third parties and constituents. Now, this element also has another practical element that as regulator, you need to also prioritize in the sense that you have on the one hand this vast body of rules that need to be implemented and monitored. And on the other hand, you want to set some priorities in terms of things you really want to realize. So you need to really act smart with your time and with your resources in order to bring it home. Now, maybe let me stop here because otherwise we will dwell off indeed in the gender of angels all the time. No.
Okay. Thank you, Rita. Would you like to add something, Massimo? Or?
Perhaps just one very short comment, which is that although competition policy will not have the predominant role in the application of the DMA, and this is by design, I think without the experience that the European Commission notably and also other antitrust authorities have had in the enforcement of 102, which I was critical before, but I think most of what we have learned is something which has actually entered into the provisions of the DMA. And I don't think this is finished yet, in the sense that I guess as there will be in the future, the enforcement of 102, which might be made by the European Commission and by the antitrust authorities, the national antitrust authority, might well inform the changes and updates in the DMA. So I think this is something which should be taken into account into the relationship between the two.
Just to add very briefly on what I think Massimo said and the point about the dynamics that Martijn and Rita underlined, I think indeed one of the issues that we saw in enforcing competition law in the digital sector is the huge asymmetry of information, whereby as a competition enforcement agency, and that's the ex post dimension, you really need to start from scratch in building your case. And that's where, for me, indeed, there is a fundamental change in the dynamics with the Digital Markets Act and it being ex ante, that it imposes on the limited number of regulated companies also a burden to show compliance with the specific obligations, and that's not just an obligation de moyens, but an obligation de résultat through the compliance report and others. And I think that is an important change in the dynamics. Indeed, those limited number of gatekeepers know that this will be an ongoing relationship with the regulator. At the same time, knowing who our clients are, I would also be cautious not just to emphasize the dialogue aspect. Yes, it's true that we don't need to get it right from the first time, because this ongoing relationship allows to, forcing the screws gradually, as also has been done in other sectors. But I think it's also important to keep on emphasizing that from the 7th of March 2024 onwards, that's not the, it's not the start of a dialogue. It's also a moment where we expect to see compliance in the first place, with heavy possibilities of sanctions if that doesn't happen. And at the same time, of course, we need to continue working on our traditional instruments. 102, as you know, is under review, and also procedural aspects. We're looking at that in the context of Regulation 1 as well. But we'll come back to that, no doubt, later in the conversation.
Thank you. Well, I will take perhaps the question precisely with the end of your session. I mean, you said that traditional enforcement provisions, 102 basically, will still apply. Mm-hmm. And my question, I know it's quite basic, but when and how it will apply? Because one of the kind of defenses that heavy regulated companies have always is that, look, we cannot move even a finger because everything is regulated. I'm over-regulated. I cannot impose excessive prices. I'm thinking about pharma sector and other sectors. So to what extent, precisely in the digital sector, these companies are going to be surveyed so heavily? They need to provide these compliance programs that have to be approved by the Commission in this element of dialogue and permanent contact. If they carry out perfectly well their compliance programs that is being monitored, how are they going to be sanctioned ex post via Article 102? What was wrong in the, because if it happens, then something was wrong in the conception of the compliance program ex ante. So I know it's quite basic, and we theoretically say, yes, you can combine, of course, regulation ex ante, and these companies are still subject to 102. I agree. But in the practice, how will it work? To what extent will we have, let's say, shared responsibilities there's a defect of design of the compliance, defect of surveillance, maybe things that are not covered by the compliance completely, and are completely new activities. So what is the interaction and how this will apply?
This is between Inge and me. I can maybe start, and then you can complement, because to me, I'm not completely subscribing to your concept of, a company can be completely complying and there will be problems left. So this is precisely captured in the notion that a compliance report is not a paper exercise. It's really about compliance on substance. It's about effective enforcement of the implementation of the provisions of the DMA. So the work needs to be done now by the operators, and they now need to put their solutions in place, and then they can write up before March what they have realized. If this is perfect, there's an effective implementation, we see with stakeholders that this is the maximum that can be achieved, then that's fine, and then we can monitor. But they cannot hand in a nicely written paper with a lot of underlying problems that will continue to exist and will perpetuate a situation that is not compliant with the DMA. So and then I think it's over to Inge for 102.
Yeah, The DMA, of course, reaches very deep and has a lot of impact, but it also has a quite limited scope. As Martijn also said already, so far we have 6 companies designated as gatekeepers for 22 core platform services, but they have many activities beyond these core platform services. And that's, of course, where competition law being, if you like, the more precise instrument to also investigate conduct which is not being prohibited by the DMA, is well suited to do in more detail the case-by-case assessment of what the impact of that conduct is in the given circumstances. So there is plenty of scope beyond the DMA where competition law instruments at EU level, at national level, remain the tool to enforce and to keep markets open and competitive. When it comes to the territory that is covered by the DMA, the scope of the DMA, there, although from a legal perspective, Article 102 can be applied in parallel. From an efficiency perspective, it's clear that the DMA has a lot of advantages from an enforcement perspective. So there, as Rita says, the compliance reports and the effects that we expect to see and will monitor through the compliance reports will give the first indication to then continue enforcing through the DMA and making sure that the results are there. From an enforcement perspective, of course, the DMA is an easier instrument to use in the sense that there are a number of issues, market definitions, finding dominance, which is not relevant, and the obligation is specified in the DMA.
Fully agree. Would you like to add something?
Yeah, maybe add a bit of the kind of the national competition authority perspective in the sense that I think all competition authorities, probably all authorities, do not have an overwhelming amount of resources. So we need to spend our resources efficiently, and that means that there should be no overlap in regulatory activities or enforcement activities, and there shouldn't be any gaps either. So it's no overlap, no gap policy that we adhere to at the ACM in problem solving, in basically, coming back to what I said earlier, in protecting and stimulating competition. And that requires, and that's also maybe some element that the DMA and the DSA and the other digital regulations bring about, that requires even more closer coordination of activities, both at the levels. The national authorities need to coordinate closely with DG Comp and DG Connect to ensure that there are no overlaps and no gaps. But at the same time, coordination at the ECN level is important between the Commission and the national competition authorities. But let's not forget that there are also other authorities looking at the digital sector, like the data protection authorities, the media regulators, in some cases the telecom authorities. So that also requires at the national level quite a detailed coordination mechanism, and that's why we in the Netherlands set up now almost 2 years ago a digital regulators cooperation forum, which is chaired by the ACM, together with the Financial Conduct Authority, the Privacy Authority, and the media regulator, to ensure, all of us, to ensure that there are no gaps and no overlaps between the things that we do. Because I think the worst thing that we as an enforcement community, wider than competition, can do is, all run after the same topic and forget about the rest. So that's why close coordination is key to the success of the digital regulation.
If you don't mind, I'm going to take property over that expression. I loved it. No overlap, no gap policy. I think it's very constructive and efficient. And starting from there, I will pose also an additional question that I think it's addressed also to people from DigiComp and to yourself, Martijn, is what kind of role do we expect that national competition authorities will have in the implementation of the DMA, different kinds of models? And also, the first one is the competition authority, the role, and the second one is the national regulation role. I mean, I'm very concerned about having national developments regulating the digital markets, how this will affect an integrated European market. Same companies, different rules in different countries, all of them inspired by competition law. I loved what you said. I was not aware of it, but I think it's quite efficient. This digital cooperation forum, it's at a national level, of course, but I think that something similar, and I know that the idea of the DMA is that everything is centralized at the European Commission's level, but something similar should exist between member states and the European Commission, precisely to ensure no overlap, no gap policy, because I think that one of the most heavy concerns for companies is precisely this legal uncertainty. You talk about boxes. Yes, we have square boxes in our minds, unfortunately, and the worst that can happen is that we have different legal regimes at a national level, overlapping one to each other, needing to adapt. So, to make the story short, 2 questions. What's the role of national competition authorities? How they cooperate, how they integrate? What's the role between DG Connect and DG Comp? We know you both apply the DMA, but how? You will meet at a coffee break. How do you do that? And the second part is national regulations affecting digital markets versus DMA. Thank you.
Let me first also, in fact, highlight that there's one dimension that you're forgetting, which is the cooperation between regulatory authorities at the European level. This was what Martijn was already mentioning, but the manifestation of that is the high-level group, which has representatives of BEREC, of the media regulators, of the consumer regulators, data privacy regulators, and the NCAs. And I must say we had such a group a few months ago, and it was really an interesting and again, unprecedented experience, because all these groups, I mean, they have about 27 members, and normally they would always act en groupe, and none of them would have representatives speaking for them. But this constellation required that there were only 6 representatives of each. So we had, I think, 30 members who were speaking on behalf of their own constituency, which I think is never seen of. And we could not have worked with a group of 5 times 27 representatives. That would have been a parliament. So this was very interesting. It's also indispensable because, I mean, also the DMA raises many questions that fall in different fields. And you have, of course, the telecom authorities, where obviously the messaging services are relevant. But there's now also a recent question that is heavily debated already in the press, which is whether Facebook can say, you can have a binary choice. Either you consent to your data being collected, or you pay me a subscription fee. Now, this is something that is very relevant under the DMA, but also under the GDPR. So we need to work together with the data protection authorities. So this is what we're doing. Now, DG Connect and DG Comp, it's much more than coffees. It's also unprecedented. It's a real team of now growing to 80 people that works on a daily and nightly basis together. So, of course, in meetings, but also virtually. And it's really one team. So the members of the team are in the case teams. So case teams exist of Connect and Comp people. We also prepare all the decisions for a hierarchy and for the commissioners together. So it's really one team, and in that sense, it's much wider than the telecom cooperation that used to exist of one team, one issue. We have, I don't know how many, I think going to 12 or 15 case teams who are dealing with the various issues. And of course, there are no less than 6 gatekeepers, many investigations en route, all dealt with by teams of the 2 DGs. So we really intensively work together, but indeed the interface on the competition cases is DG Competition. So then that will be over to Inge.
Yeah, I mean, just to echo, I think that's already a signal also of the depth of integration between us on how much what we are saying is very much the same on this. I do think that when it comes to surveying digital markets and making sure that they are contestable and fair to consumers, it's such a sheer complexity and an amount of work that needs to be done that the only way to do it effectively is with an efficient enforcement ecosystem, I would say. And that is one where everybody focuses on where that authority can add most value and core competences, and it's not something which you can easily square in boxes, but the intensity of the context between us and the depth of the dialogue between us is what brings us to this no gap, no overlap results that we aspire together. And I think on the ground, that deepening of the intensity of cooperation, whether it is in the ECN between us and DG Comp and the national competition authorities, whether that is with other regulators at EU level, as Rita says, at national level that are taking place, this is changing so quickly by the month, I would say that is very inspiring and very hopeful and very useful, because we see on the day what it brings us. If you look at these complex problems from various perspectives, bringing the various experiences and skills, and I think that is the best motor to keep that to keep on deepening that cooperation. And there are various instances that we have and that we use that work well. The ECN is one of them. There are new ones that we create, a high-level group, and also at national level, new bodies are being created. Martijn highlighted it for the Netherlands, and that's very, very promising. And it's a living animal, as the Secretary of State also said, and we will keep on learning and adjusting as we go along. If the landscape becomes too complex, then maybe at some point there is a reason for streamlining. But right now, I think this ecosystem approach, also for us as enforcers, is what to me looks most promising.
Understood. Just before you also answer, Martijn, we have to keep close to the microphone. Probably it's my mistake that I move a lot my face, but because we have people also streaming, they would prefer to listen us directly.
Yeah, thank you, Patricia. Maybe to give a bit my national perspective here, and I am a little hesitant here, and the reason why I'm hesitant is that I think one of the beauties of Europe is its diversity. So I don't want to say that how we have organized this in the Netherlands that everyone should do it, but at least we are happy with it. So I think the way we look at it, we have what I sometimes describe as a dual identity. We are a national enforcer in the Netherlands, but we're also a European enforcer in the Netherlands. And that's why I think on the basis of particularly that second identity, we have an absolute duty to make the digital regulation a success. And we can only make it a success, we can only make a success of the political will to regulate the sector if we work together, both at the European level, at the national level, and in between the European level and the national level. And that means that in the Netherlands, we are organized in a way like I described earlier. We have lots of these powers with the ACM. So we are going to be involved in the DMA, in the DSA, in the Data Governance Act, in the Data Act. And of course, some of these certain parts of the rules and regulations from these acts will be shared with other authorities, notably the Data Protection Agency and to some extent the media regulator. But I think by bringing together all these agencies under the umbrella of the Digital Regulators Cooperation Forum, there is no dogfight before Parliament between us regulatory authorities. And in effect, we all, the heads of the different regulatory bodies went together to Parliament and said basically, this is how we would organize it. Of course, it's your job to assign tasks, but if you would ask us, this is how we would do it. And that is how it happened. So I think that by showing also at the national level that deep kind of cooperation is also something that our parliaments want. You know, they don't want fights between national authorities. You know, they like a coherent approach. We deal with how to divide up the work, but that should not be something that needs to be discussed in Parliament. At the same time, we were also asked whether we wanted to have a national DMA at some point in time. And I think there were members of parliament who thought, okay, that may be also something that would be nice for the Netherlands. We advised against that because we said, you know, this is going to make things very complicated, unnecessarily complicated. I mean, there is enough work to do, and on the basis of the no overlap, no gap policy, you know, why would we need a national DMA? You know, if it would it all be possible, but the idea was floated. It's no secret that we as a national authority hoped for kind of a more involvement in enforcing the DMA at the national level, of course in close cooperation with the European Commission. In the end, European Parliament and the Council decided differently. That's fine. And now we're looking for new ways to cooperate. And I think one of the most promising new ways of cooperation is that we have people from the ACM working side by side in teams headed by the Commission in DMA enforcement. So it's not a secondment program. It's not you do this and we do that. No, it is actually working in a joint investigation team, which was modeled after how the financial authorities and the banking authorities in particular work together in banking supervision. And I think that is probably the way forward. And I hope that more competition authorities with an interest in enforcing the DMA will also join in this initiative and strengthen the Commission's resources with sending people to Brussels to work together on DMA enforcement. And the great thing about it, also from a employer's perspective, is that our people really, really like it. They stand in line to work together with the Commission in on these cases, and it has, you know, the benefit of a flexible workforce. I mean, they're not seconded for a longer period of time. Some people have, you know, have families, have, you know, different career plans, have spouses with work in their home countries. So, you know, being seconded for 1 or 2 years to Brussels is not an option, but working together, partially on-premise, partially remotely, is an option to work together at a European project, and they find that extremely exciting.
Thank you, Martijn. Definitely you are applying, let's say, law firms' policies to retain talent. And I think it's extremely important what you're saying about not secondments, but this exchange of experiences, definitely. Massimo, I have a question for you, because for me, it's so basic that it's wrong. But I always thought that, you know, combining forces within the same authority, having knowledge and sharing experiences, because I'm sure that the DMA, the DSA have things in common. There are efficiencies. And also the competition authority having all this background, as you said, Massimo, that is quite interesting to have this background in order to apply the DMA. I think also the DSA. To what extent, from a pure economic perspective, you think this brings efficiencies? To put all these competences under the same umbrella authority as the Dutch have done, I think I'm not saying that we need to copy the same model, but I think it's quite efficient. Also, did you connect? You have similar approaches, so it should bring some efficiencies, I guess.
I don't think I'm an expert in how to design institutions, and each member states and indeed each jurisdiction can find its own way. The ACM has a particular structure, and it makes sense, but the other countries have decided in a different way. So I don't think that there is one model which is prevalent to the other in general. When deciding about the DMA, DSA enforcement, there are a couple of thoughts which come to mind. And one is, of course, that there might be interactions between the enforcement on one and the other, and that might be taken into account. But the other one is that each agency, as long as the agency is not taking responsibilities both on regulation and competition, but each agency has its own expertise and its own knowledge. So for the DSA, I can think of of course, knowledge about, video, I mean, the media industry, that is very important. So if there is a country where there is a media regulator, a communication regulator, it would make sense. But it also has an element of consumer protection, so which is important. So, for instance, in my country, I'm Italian, despite the fact that I live in Spain. But in my country, I can see that the antitrust authority has also competence in terms of consumer protection. And then there is the AGCOM, which is the communication authority, which is, of course, has competence in the media. Now, it has been decided already some time ago that the DSA should be enforced by the AGCOM, that is the communication agency, which might make sense. But in my opinion, it might have made sense also for the antitrust authority to be in charge of the DSA for two reasons. First, because it has this competition expertise, and because probably it has not been decided yet, but especially after the Commission has taken a stance on this, it will be the Italian Antitrust Authority which will be in charge for the DMA. So there are two considerations: one which has responsibilities for consumer protection, and the other one which has responsibility for the DMA, which would have made sense to put it in his hands. But again, it depends on a little bit on what are the different expertises and the different institutional designs of the different countries. I don't think there is a magic recipe there.
Thank you very much.
Do you want me to say something about
Of course.
DMA? So indeed, it's very nice that you both bring up also the DSA, because indeed in DG Connect we do this all under one roof, in one platform directorate, and that makes a lot of sense. I mean, it's also nice to put the DSA on stage in this environment of competition authorities, because at the same time as the gatekeepers are implementing the DMA, they are, and 11 of them are also very large online platforms which are implementing the DSA. Now, for us, it brings a lot of synergies to do this together, although at the far end, there are also many differences, in the sense that the team that enforces the DSA has experts on hate speech, on terrorism, on far-going criminal activities, on pornography, on copyright infringements, defective products. So it's a much varied team. At the same time, they apply the same procedural rules. So the procedural rules are the same. And also, I mean, what I always like to think is that there are many synergies from applying on substance also DMA, DSA. So DMA has many rules, for instance, on advertising. And it will now give advertisers much more information on what they're actually paying. They will have real-time information about the effectiveness of their campaign. Also, the whole landscape of data collection will change, in the sense that we will no longer have the data lakes, but there will be a more competitive situation where the individual gatekeepers will have less data that they can combine, because consumers may not always consent. At the same time, the advertisers will be more visible under the DSA. So under the DSA, it is necessary that a consumer knows, when am I facing an advertisement, what are the parameters with which I'm being profiled, and the advertisers need to be mentioned in a repository. So that means that on the one hand, they're much visible, their choices are more visible, but they themselves also have more choice. So it's the combination of the two acts that brings these effects.
Thank you very much, Rita. I think what you say is quite sensitive and logic. So let's see how it evolves in different jurisdictions. We have still 20 minutes. I'm going to launch the last question so we can open the floor then. And of course, if nobody asks, I can still make more questions, which is not my intention. But I launch the last one, which is very typical. But it's necessary. What are the challenges that you expect in the implementation of the DMA in the future at a national level and at DG Com's level? And second, and this is probably for you, Rita, if you can give us some headlights of what's going on in Brussels, what, apart from having appointed 6 gatekeepers, what is moving on? Do we have judicial challenges, investigations, etc.? As far as you can tell us, of course. Thank you very much.
Indeed, if I can then start. So right now it's a lot of work. So we've had the designations. Says 6 gatekeepers have been designated for all in all 22 core platform services. Now there are roughly 20 obligations in the DMA. So in a worst case scenario, you can multiply what are the obligations that we would, in theory, need to supervise. We've had kick-off meetings with all the gatekeepers, and they are now working on their compliance in very close cooperation with us, which means that we need to identify which are the provisions that are not relevant for them, which ones are relevant but more or less addressed, and which are then the key provisions that are really relevant where we need to bring about changes. So there, we've really advised, encouraged, and even stronger encouraged the gatekeepers to work with their own constituency, with stakeholders and with third parties to make sure that they bring the solutions that are acceptable. Now, this is of course challenging because for some areas which have a legacy already in competition law, the constituency is clear. There are many quite unhappy players who really want to use the DMA now to make sure that they can realize what they have always wanted to realize. But there are also areas where the gatekeepers are telling us we don't know who has an interest in this. So it's very important also that in the digital atmosphere, the players who may have an interest in an effective enforcement of the DMA come forward. And it doesn't work in a way, I mean, we've had that also, where a group of stakeholders comes forward and says, can the gatekeeper give us a catalog of what we can do with their data? This is not how it works. I mean, they need to think about this themselves. They need to, have the dialogue with the gatekeepers on their own business models, and they cannot treat the gatekeepers like a kind of ministry that gives them a business case. So this is very challenging. On top of that, we are dealing with 4 market investigations. You know that there were rebuttals in the notifications of the core platform services, and we're investigating for Bing 3 services, for Apple iMessage, and we're seeing whether they should be designated or they should not be designated on the basis of their arguments and on the basis of a market investigation that has many elements of a second phase merger investigation. So it's quite comprehensive. We're also doing a qualitative investigation on the iPad operating system, where we have a little bit more time, but we want to finish early. And then, of course, we do not exclude that there will be appeals. Now, we don't know. I mean, of course, appeals can happen. They will not necessarily hijack much of the time unless there will be a request for injunction. Under the DSA, we had 2 appeals, which we are dealing with. And there was 1 injunction procedure. There's a court order now also. So we're reflecting on what will we do with that court order. We're also analyzing whether that will have repercussions from DSA into DMA. So this is the whole, let's say, horizon of the work that the colleagues are dealing with. It's a lot. And the key element is how to make this as effective as possible, because we want things to work in March 2024, and we want there to be results on the ground. Now, it looks promising that that will effectively be the case. In most aspects, we cannot complain about the level of engagement of the gatekeepers, but of course, much needs to be done.
Exhaustive list of what's going on, definitely. Well, any contributions on future challenges, national level? No? Okay, then I think we can open the floor to questions. No one? Then I have another, well, I have many more. I will take just the advantage. Of course, Gani. You have the privilege, so dominant position, definitely.
Thank you very much. I have a question for Massimo Muta, and the question is the following. We've heard that we've been under-enforcing merger control. And in the digital, in particular, in the digital area in particular, we feel that it may be the case. But I have a question. What would be the impact of more blocking enforcement of merger control in digital markets for the innovation, for the startups that view as a potential achievement of their goals being bought by another company? I mean, you know that there are many startups that would not expect to really grow very much, and there are economies of scale as well. So what do you think is the right balance between one and the other? Thank you.
Thanks, Kani, also for bringing up a subject which is close to my heart, because as Patricia mentioned. So I think there is a lot of misunderstanding about some of the positions which have been presented some of them have been exaggerated. Some have advocated for a moratorium of mergers. And of course, this, if this was the case, then this might have important ex-ante negative effects. But I think that the most reasonable positions are first that there should be more possibility to investigate mergers, which brings about the issue of notifications and how to deal with that. Now, I would have personally preferred to have that in the DMA there was an obligation to notify for the gatekeepers. It has not been so, just a right to inform. Perhaps with the Article 22 guidelines by the Commission, there will be a way to deal with that. So, in any case, we are not certainly going to a direction of over-enforcement for the time being, in my opinion. But coming to the question about what are the effects of strict policy, say, against acquisition of potential competitors or startups, etc. Many people have, as you were hinting at, have said that this will have an ex-ante effect in the sense that startups very often are innovating and are introducing new products because they hope to monetize by being bought by another company. And so couldn't a strict policy have an effect ex ante on innovations? I don't think so, for the following reason. First of all, that nobody says that, apart from very extreme cases, there should be a moratorium. What most people are saying is that there is a dominant platform in a particular sector or in a particular service, then it's not that dominant platform which should acquire a target which is operating along a dimension which might become a potential competitor. So say if we were talking about Google Waze, probably the worst thing would have been that the one which happened, that is that Google, which owns Google Map, was acquiring Waze, but others could have actually acquired Waze instead. So this is the first thing. It should be something which makes sure that it is the dominant firm in that particular area, which cannot take over the startup. The second thing is also, which is also very important, is that if you are in a situation in which the startup has some hope to be able to develop a product which is going to be in competition with the big platforms, then this will be very valuable, and this might indeed allow these startups to fetch a very high price. But what happens is that if the dominant firms becomes more and more dominant, then will come a point where the startups, no startup will be able to have the possibility of jeopardizing the position of that dominant firm, which means that it can fetch very little price, and which means that the ex-ante innovation effect, which is probably not going to take place anyway.
You wanted to add something?
Yeah, if I may, some comments also from a merger control perspective, because it strikes me that on the one hand, and this is of course something that we've seen in all times, there are calls for more relaxation, and on other sides for being stricter. So in digital on being strict, but also calls for relaxation with regard to other markets, despite them being highly concentrated as well. I think the way we look at it from the Commission's perspective is really that every case needs to be looked at afresh and on the basis of a merit. And what Massimo said is the possibility of investigation is very important in jurisdictional terms, and there the obligation to inform the Commission combined indeed with Article 22. The first results of that, I think, give us comfort that it indeed works and allows us to take jurisdiction over cases that deserve to be looked at. The other element is, of course, again, in terms of resources, there the simplification exercise was very important for us to deal with more simple cases fast and not to spend too many resources on them in order to free them to investigate in detail the more complex cases. But then on substance, when it comes to these complex cases, and we've seen a few in the digital sector, I don't think we have been shy to develop also their new theories of harms, innovation theories of harms. It's of course tricky, and there we need as enforcers to coordinate closely, to discuss with each other within the EU, but also globally on how to go about it. This is another area where I think competition law needs to evolve, but it is evolving as well. And our approach is that we prefer to do that on the basis of the cases, because every case needs to be looked at on the specific details.
Very interesting points you raise. I think empirical evidence shows, and there's Bruno Pellegrino that actually done this, that IPOs versus being bought, well, things changed at the late 90s. So until the late 90s, you know, startups were preferring IPOs. Since the late 90s, they preferred being bought. And probably that shows why, you know, that they see little likelihood of success on being on their own, standalone, basically trying to introduce competition, which I think is a very important issue to take into account. And I think a recent paper by Nicolas Petit and Mark Ivaldi that basically looked to some of the mergers the Commission has been looking and then basically saying, well, you know, they scaled. Well, I mean, that was probably the only choice that they had at that point. So, but my question refers to the cross-fertilizations between competition law and the DMA and the DSA. I mean, so far we have seen that competition law has been influential in, you know, some of the cases that we had to create all this list of the DMA. But then my question is, now that we have the DMA and the DSA, how they can influence competition law enforcement. I have two possible ways to think about that. First, is the list that we have the DMA going to probably lead some courts, but also some national competition authorities to develop some kind of by-object restrictions when they apply abuse of dominance? Secondly, is the DSA, you know, discussion about non-price, you know, harm, like let's say quality harm, in terms of, you know, hate speech, in terms of, you know, this type of activity, could that be taken into account to build up basically quality-based theories of harm in the context either of merger control or in the context of the enforcement of Article 102? Now that we also have the meta case of the Court of Justice as well, which enable us to build up basically different theories of harm, which are not price-based, basically, very much regulatory offenses type of theories of harm. Thank you.
I think that's a very interesting point that you make, Johannes. On the first point on by-object restrictions, I'm not so sure whether specifically the DMA is there leading to results. I think in general, of course, one of the issues when it comes to 102 enforcement is whether we can be fast enough and whether we can efficiently enforce 102. And that's our prime objective, to make sure that we can continue to efficiently and effectively enforce 102 so that there is no gaps and no overlaps, that there is no under-enforcement and no over-enforcement. And I think that's why we are preparing for guidelines when it comes to 102, where we hope to go into more detail. But I'm not sure that the DMA is what led to this exercise, or whether the outcome should necessarily be by object infringements under 102. I think on non-price harm, again, for me this is a broader trend which was already ongoing, probably alongside the diagnosis, which led us also to propose the DMA, that indeed there are other parameters of competition beyond price which are very relevant, including quality, choice, innovation. And therefore, I think throughout our policy documents, but definitely also the cases, you see that emphasis being put more frequently also on these other parameters of competition, which are important in antitrust and in merger control. I think a third issue where maybe most directly the DMA experience can also be relevant for antitrust and mergers is how you go about remedies design and about monitoring of remedies. And there is where I think there might also be some cross-fertilization and experiences in DMA enforcement that may feed into competition law enforcement.
Can I just add one thing which is related to what Inge was just saying, which is about Article 102. So I think that we start from the same point, that is that the way in which 102 has been enforced has been too complex and too slow. In the case of digital platforms and gatekeepers, this has led to the DMA, with a list of provisions with do's and don'ts. But I think it would be desirable to move not so extremely, but in the same direction also with the guidelines of Article 102. That is, to use what we know in terms of economics, in terms of the case law, etc., to draw sets of presumption, which is presumptions which can be rebutted in the case of the 102, unlike mostly for the DMA. And this, I think, will help considerably in the enforcement of 102. And this is, I would argue also, that is completely in line with economics. Effects-based approach or an economic approach doesn't mean that each case is different and should be done in a completely different way. It means that you have to learn from what you know from the different case law, from different cases, from economic theory, from empirical evidence, so that you are able to prepare a list of presumptions which can actually help the Commission and obviously all the national antitrust authority to enforce 102 in a much more efficient and speedy way.
Martijn.
Yes, thank you, Patricia, and thank you, Johannes, for the good question. That also brings up kind of a broader discussion, building on what Massimo said, is that the effects-based approach and economics in competition law has brought many good things, and I think there is now a time when we also have to think whether we set up a beautiful, very good, solid, academically well thought through system that perishes in beauty because it is in fact inadministrable. And there, you can say, well, okay, but at least we get it right, despite, we only do a couple of cases a year, but at least these cases are right. And that is in a way true, but that leaves out all the other cases where we do not have sufficient time to deal with them. And that will provoke a response by Parliament, basically adopting more specific regulations to make it easier. So I think we have to rethink the balance between effects-based approach, presumptions in law, like you are subscribing to, in order to create a system where 101 and 102 are still in practice administrable by competition authorities in Europe. We cannot let this entire system basically die in vain of the beauty that we created.
Thank you, Martijn. Well, I think we have one last question.
Yes, thank you. Yes, to add some data to the comment by Ioannis, that's we have a recent paper that says that more than 50% of the venture capital startups in the last 20 years have been acquired. So I think we have to be very careful on what to do with mergers and acquisitions in order to, because we're dealing with a big amount of companies. On the other 50%, 30% fail. So there's only a small part that go to an IPO. Just one question. I think you're very. I think you're very busy now, so you're not thinking very much about the future. But I presume that the objective of the DMA is to protect consumers, right? So is there any exercise, any ex post effectiveness exercise planned in order to assess what's the effect on consumers of the DMA? Because as what Martin said, is simple rules are for complex problems are easy to implement, but their effectiveness have to be proved too. So that's a bit my question. Thank you.
But these are the questions where I always take the law to the conferences. There is a review by May 2026, and there I think the whole DMA is open for review, no? But you know better because you've been negotiating this, I think.
Oh, I think, you know, the DMA no doubt will also be an iterative process, I think, from many perspectives. But one, of course, KPIs to keep an eye on this is what it brings to consumers. Indeed, it has a more direct fairness component. But again, I think that will be something which has is multifaceted and is not just related to price, which in any event in digital is sometimes a difficult concept. It will also be related to privacy of consumers and other aspects. So I haven't thought about it in detail on how you would break it down in terms of measuring concretely what the impact on consumers would be. Maybe that's something that we should think about when we have some time. But again, I think, of course, just like with competition law, also the DMA, to the extent that it zooms also in on the contestability on markets, the impact on consumers is in that sense through having long-term competitive markets and to having that drive of competition law and of pro-market regulation to stimulate for economic efficiency, to stimulate for innovation, for diversity of products and services, for quality. And that is something which may not be easy to measure between March 2024 and 2026 already. It is something which generally also takes a longer time horizon to really monitor and judge what the impact on consumers has been.
Yes. Well, it's an intense debate, as you can see.
But I think also, so indeed, I now saw that the clause has effect also on business users and users. But I think one needs to reflect also whether we want the effect of the DMA to be that in 5 years there's a new Google in Europe, or we want that there's a thriving climate of startups and bigger companies who are building also on the ecosystem that has been opened up by the DMA. And so to me personally, I was not only in telecoms and in other elements in DG Comp, but also closely involved in the payments market. And there we opened the market by giving access, in particular to digital companies, on the infrastructure that banks had a monopoly on by then. And now we have a flourishing landscape of fintechs in Europe. And we are the first in the world to have that. So in that sense, I think that's a perfectly legitimate aim, no? Also for the benefit of consumers, to aim for that.
And I think maybe last element as well is that in the way in which the gatekeepers need to comply with the DMA, how consumer friendly they will be in designing the solutions, I think that is an important question where we are also looking at the gatekeepers to see how they approach it. And they may not approach this the same way. But again, I think there are sufficient safeguards also in the DMA from a legal perspective, also in terms of anti-circumvention clauses. And again, seeing the results and in the compliance reports as well, there will be performance indicators in terms of, do consumers really switch? Are they indeed able to port their data to other providers where we will keep an eye on the compliance to make sure that compliance is also taking place in a way that is consumer friendly and not just compliance on the letter to sometimes maybe even give an indication on why this regulation does not bring benefits to consumers. So I think that is something that in the choice of or in the design of compliance solutions, we will also have the consumer interest highly in our minds.
Thank you, Inge. It has been extremely interesting. We can even drop more questions, but I think it's time for coffee, and we can pose them at a coffee break. Please be back at 11:30, if possible. And of course, all the panelists are open to discussion with a coffee. Thank you very much.